Good evening, everybody, and welcome to the interview room. Hopefully you're doing well. Let's remember why we're here tonight. Ethan, Maddie, Kaylee, and Xana. Justice will be done. Forever 20. God bless their families. Now they can get on with the next phase here.
Say one thing we have in common. It's like my teeth just cannot stop it. I don't know suddenly come small talk.
Give us a couple more minutes here while people are just coming in. Thank you for being here.
I don't know suddenly come small talk. I don't know suddenly come small talk.
Well, a big day in Boise, Idaho, and the judges made a decision. We're going to go over those decisions tonight, and we want to welcome everybody. If this is your first time here to the interview room, we appreciate you being here. Karen and I are so grateful for not only you and our subscribers, our Patreon members, but our mods. We have the best mods. I think you would agree on the YouTube platform. Maui Girl, Mimi J2, Laura, Teresa M, and Miss Sophia. I mean, just it doesn't get any better. And without these women, we couldn't do this. But more importantly, without you, we couldn't do this. And we have just one request if you're brand new to our channel, and that you just hit the subscribe button, please, and that you send this out to all your friends and family. Well, an absolutely huge day here. There are some folks sitting in jail scratching their head, i.e. Bryan Kohberger. And he's innocent until proven guilty now in front of a jury of his peers. And now he's going to get the opportunity, and the prosecution's going to get the opportunity to present all of the evidence that the defense tried to suppress. And here we are, a couple of years down the road here, and we finally got a judge who looked at the totality of the circumstances, the totality of the evidence, and came up with a decision. And unfortunately, the decision was not in the defense's favor on 4 different levels. And we're going to go over each of these. I'm going to kind of give you the highlight in terms of, from an investigative perspective and a legal perspective. I mean, I've been in this game for quite some time, so unfortunately, I actually understand what this stuff means sometimes. But I am not an attorney, and if you need a deeper dive, there are many attorneys on YouTube that you can watch as well who will give you a deeper dive into this. But so there were 4 motions to suppress. One of them is the first one that I have in front of us here. And this was going to be the IGG, or the genetic genealogy. And so I have the motions right here and the rulings, how the court ruled today, and what he saw and how the case law applied. Remember, our system is designed with checks and balances. And sometimes you have to, go through what we call pretrial hearings, and these checks and balances have to be measured. And once a court has ruled, after hearing all of the evidence from both the defense and the prosecution, then it's over. And that means whatever he decided today will come in, because it was the defense's argument that evidence should have been suppressed, primarily based on a couple of theories. And the prosecution, the defense, Ann Taylor came in with some arguments and connected case law to those arguments, but it didn't necessarily mean that those arguments apply. I remember on one of her motions, she talked about international law, and the judge in the lower court in Latah County said, no, that's not going to fly either. So she's doing her best and doing her job to throw as much at the court as possible, hoping that something was going to stick. Unfortunately, today for the defense side, is the judge came up with a very logical ruling on all 4 of these motions to suppress. And he lays it out very clearly about what the totality of the circumstances were, and how law enforcement was taking those circumstances minute by minute, and then applying it to the law, and then applying it to search warrants, and then ultimately into investigative tools and investigative steps. So having done that many times, I've worked well over 300 murders and probably close to 400 to 500 death cases. That includes naturals and suicides. But I've been in front of many judges and have had to swear, under oath in an affidavit about the evidence that we collected at that time, and that we were going to be asking you, the court, for give us the wherewithal to get additional evidence. And that's essentially what an affidavit is. And then, of course, when a search warrant is issued, you take that search warrant based upon your, you being the affiant, and you send it to the agency or the company or whatever it's going to be, asking them for the information that you're looking for. And so in this case, there were two major decisions made today. I mean, all four of them are major, right? All the warrants for Google, et cetera, even the search warrants in Pennsylvania, Kohberger's house at the university, all of the AT&T, Amazon, all of that information that the defense was hoping to suppress, saying it was unlawfully collected, that the law enforcement, were outside of their league and they should not have gotten this. And what would have happened had that occurred is what they call fruit of the poisonous tree. And what that means is if it was a violation of the individual's Fourth Amendment, then everything that you gathered the moment that violation occurred would be suppressed in a court. And the judge would suppress it and a jury would never hear it. So that was the argument that Ann Taylor was making to the court about how the evidence was collected. And these are what you would call procedural, arguments. What was the process used to collect the evidence? And then, you try to convince the court by using case law that your argument is extremely, not only probative and convincing, but within the bounds of the case law that you're citing. And that's what they did here on the IGG. And so this is the first warrant here, or motion to suppress. And you'll see, obviously, and I'm going to kind of give you an understanding of how these things, lay out for our folks maybe overseas. I know we have a lot of folks in Australia and, the UK, all over the world. We love you and we're grateful that you're here. So this is United States, law and how it works. And so here, the defendant is charged. So the judge is basically going to just give you a synopsis of the totality of the argument. What's going to be the argument? And so that's where the introduction paragraph comes in here. And he says the defendant is charged with 1 count of burglary, 4 counts of murder in the first degree. It's alleged the defendant entered the residence, 1122 King Road, Moscow, Idaho, and stabbed Maddie, Kaylee, Ethan, and Xana with a knife. Left at the crime scene was a knife sheath with a single source male DNA, where a single source male DNA was extracted. Using forensic investigative genetic genealogy, IGG, law enforcement was able to identify defendant as a possible suspect weeks after the crime occurred. Subsequently, law enforcement conducted a trash pull from the defendant's family's residence and obtained DNA tying defendant to the DNA found on the knife sheath. Defendant was subsequently arrested pursuant to a warrant and charged in this matter. And then he goes on to talk about, Ann Taylor's argument, well, they should not have, pulled the trash, and here he says in the second sentence here, he seeks to suppress all evidence obtained through these searches, i.e. the trash searches. So this is, again, the first thing that jumps out very quickly for all of us, I think, and you tell me what you're feeling in the chat. And forgive me up front if I don't pull your questions right away. I kind of want to get through, a lot of this tonight so that we can wait for the next move here, because it's going to be a really interesting couple of days now ahead of us here. So he talks about right here, he says subsequent warrants as fruit of the poisonous tree. That's what we just talked about. The state disputes the defendant's constitutional rights were violated. So the bottom line here for Ann Taylor was, look, the state had, no right under the Fourth Amendment to collect any IGG evidence at all. Zero, zilch. Okay. And because they did that, that violated my client's Fourth Amendment right. Okay. And so therefore, as a result of that, their procedures, how they did it, why they did it, where they did it, i.e. at the house in Pennsylvania, and what labs were involved, all of that information, Your Honor, should be suppressed. And it should not come in our case in chief, i.e. the defense, to defend our client, Bryan Kohberger. And so the judge, points that out here. He points out, hey, there was a suppression hearing in January 2025, January 23rd, and he heard testimony from the experts or officers, and that's what this subsection is down here, number 1. And he specifically points out what officers did what. And then the second here, paragraph 2, is, well, what's the standard? What is the Supreme Court? What does the law of the land say in relationship to your argument, Ann Taylor? And he says the standard of review of a motion to suppress is when you know it, I get tongue-tied. The power to assess the credibility of a witness, resolve factual conflicts, weigh evidence, and draw factual inferences is vested in the trial court. And then he cites the case law, State versus Valdez-Molina. And what that means is the court is the final test. The judge is the final ruling. And he goes on, a trial court's ruling on a motion to suppress evidence combines the issues of law and fact, which we talked about. What were the circumstances taking place? And how does the law apply to those circumstances? And are those circumstances within the parameters of law? Okay. And the trial court's factual findings will not be overturned unless they are clearly erroneous. Meaning, we're seeing some things take place in this country that judges don't have any standing in. And it's going up to the appellate courts, and the appellate courts are reversing those decisions. So what the judge is saying here is simply that. If I just make a decision because I feel that's the right way and I don't apply the law to that decision based on the facts that are presented to me, then that could be kicked out later on. And he says when a decision on a motion to suppress is challenged, i.e. in the appellate courts is what he's saying, the application of constitutional principles to the facts will freely be reviewed. So then he cites, what are the facts? What brought this motion to its present state, i.e. all the things that we've been hearing about for weeks and weeks. And here they are. There's some interesting things in here too, by the way, that I just learned today. Finding of facts. On November 13, 2022, law enforcement found the bodies of Madison, Kaylee, Xana, and Ethan inside a residence located at 1122 King Road in Moscow, Idaho. All 4 victims died from apparent knife wounds. A K-bar knife sheath was found on the bed next to the bodies of Miss Mogan and Miss Goncalves. Law enforcement seized the knife sheath and swabbed around the button of the sheath for DNA. A sample of DNA identified as Q1.1, so just remember that because that's going to be the sample, was extracted from the swab by the Idaho State Police Forensic Lab and subsequently tested using standard DNA STR, short tandem repeat methods. The STR profile developed revealed that the DNA came from a single source male profile. Just like the other two, by the way, one on the railing, one and something on the glove outside, those are all as well from a single male source. So that's still in play, by the way, for the defense. But it's not as strong as this. This is coming directly from that knife sheath underneath the victims. And that's a real mountain to climb here. Because the defense can say, Sod, some other dude did it. And they're going to point to that, those two, blood samples. However, they're not going to be able to show circumstantially and or put it into the environment as maybe being fresh or old. They're not going to be able to do that. And by the way, they agreed to tear that house down. So you can't go back and see where those items were on that railing. That house is gone. It is absolutely gone. And so now the defense, and I said a long time ago, you guys heard me 1,000 times, see, that's going to blow up. That's going to be a big problem once it's gone. And now I bet you that defense is wondering or is wanting that railing back today. Once that blood evidence came forward, you can bet they want that railing. They would love to take a jury or at least have a piece of that railing. And yeah, there's going to be photographs. There will be photographs of it, but there's nothing like walking into a courtroom with that physical railing and having an argument. Remember, somebody sent the defense investigators over to his apartment, and it's probably his team, his defense team. And remember what they removed? They pulled his TV, his smart TV outside or from the inside of that apartment and removed it. So the defense has that. And if there was anything on it, it would now be attorney-client privilege considered work product. And it doesn't necessarily mean they have to reveal it to the prosecution. So they may have incriminating evidence on that TV. We will probably never know. We'll probably never know. So they send it. The STR profile developed revealed the DNA came from a single source male profile. Law enforcement uploaded the DNA profile to CODIS database, but it resulted in no hits to known offenders. So that means whoever did this was not in CODIS. So the prosecution, in my opinion, is going to argue, well, that fits Bryan Kohberger. He's not in CODIS. Okay? And so therefore, you ladies and gentlemen of the jury should consider that. Okay? Subsequently, law enforcement made the decision to pursue forensic investigative genetic genealogy, IgG, testing on Q11, i.e. the sample from the sheath. Such testing begins with the generation of a large amount of raw sequence data from the DNA sample, which is then organized into SNPs or single nucleotide polymorphosis using bioinformation software. The SNPs associated with ancestry and genealogy can then be pulled out of the raw data and organized into SNP profile that can in turn be uploaded to commercial genetic genealogy databases to search for a genetic match. Now, what is personal to every human being on this earth, right? It's one thing, and that is our DNA strain, our DNA. What makes us who we are and what separates us from everybody else on the earth? It's our individual DNA. And we get our DNA from both mother and father. And those strands are then identifiable through science. And if you've not seen any of my videos I did with Francine Bardot, I recommend after this when you go watch Francine's assessment on what exactly is being broken down here. But what's happening is they have identifiable male DNA strand, and they sent it to, they get it, and then they send it to a commercial database to search for genetic match. Depending on the strength of the match, law enforcement can still build a family tree to identify potential genetic relatives on the upload SMP profile. That is not the total profile of DNA. It is just, the baby's born. But the baby hasn't had a birthday yet. So they get this baby born, i.e. genetic, a SNAP, SMP, and these genetic databases are hosted by private companies and populated by hundreds of thousands of members of the public who voluntarily submit their DNA. Now, that is crucial to understand. That's crucial to understand. Karen and I have both done Ancestry.com. We both did our DNA, and guess what? We signed off and we submitted it. And that means it's in the environment. So once it's in the environment, there is no reasonable expectation of privacy. It's kind of like, when you're out and you're drunk. I don't drink, but people who are super drunk, and they take photographs of you in public, and next thing you know it, you're on the background of somebody's Instagram page. Have a good day. We're in public. And the same thing like this. Once you release it into the environment, it is public. So now the question is, which companies allow law enforcement to get into? And that's where he breaks it down here. Notably, all relevant times, only 2 commercial genetic genealogy databases permitted searches by law enforcement at that time. That's what he's saying. Family Tree DNA and GEDmatch Pro. The databases MyHeritage and GEDmatch purported to disallow such searches. So MyHeritage, GEDmatch did not allow those types of searches, i.e., it's a private company and you can't break into their system. That's what he's saying. IgG process essentially attempts to ascertain identity through genetic associations like STR profiles. Okay. So now let's just jump down here where raw form, and she argued, well, people's cancer and, blah, 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 Alzheimer's. The judge counters that by saying, however, IgG does not target these particular SMPs because, according to defense expert Daniel Halig, her own expert, they are neither relevant nor probative nor appropriate to the identification process. So what she was doing is just throwing spaghetti on the wall without sticking to what the real argument was: identity. The law enforcement was not interested in medical research DNA processing, i.e., Your Honor, we don't care if somebody has Alzheimer's. We don't care about cancer. We just want to know the identity of the individual. So the argument that it's a medical health, HIPAA and all this other stuff is protects this, the judge saw right through it. And he says, no. And he used her own expert witness to throw it back on her. And she says, forensic scientists like Mr. Helwig have done a lot of research. IgG was first performed by Orthram Labs, a company which the Idaho Department of Purchasing had an existing contract for such work. So we first learned, this is the first we've learned, that the first lab they went to was in Idaho, and it was called Orthram Labs because Idaho had a contract with them. So it went from the Idaho State Police Lab to Orthram Labs to try to separate and get more definitive information out of this DNA. And they uploaded it, S&P profile Q11, uploaded it to these public genealogy databases, permitting law enforcement entry and submitting a preliminary report of its finding. So guess what? All of that argument that she was making, okay, was smoke and mirrors, because they sent it to a lab they had a contract with, and that lab had access to public genealogy databases. Therefore, the judge is looking at this right now going, well, that's not against the law. And it's not a violation of his Fourth Amendment. That's it. But it gets better, because Orthram was not asked to ascertain medical information associated with the Q11, meaning they weren't looking for medical problems. You know, what's my genetic disposition to cancer? What's my genetic disposition to Alzheimer's disease? That's not what they wanted to know. They just wanted to know who could possibly be in the circle connected to this DNA. That's it. That's all they wanted. So any evidence is tested for such. Law enforcement did not obtain a warrant for Orthram's work. Excuse me. They didn't have to. It's like walking into Target and they have video, and you've been and you just got run over in the parking lot, and you want to get all of this video. And yes, Gracewater, they did things correct, is what the judge is saying. Okay. And you walk into Target and say, hey, I was just run over in the parking lot. This guy ran over my foot. Do you have video? It's up to them to say yes or no, i.e. Target. If Target says yes, would you like a copy? And they make a copy and they hand it to you, okay, that's not against the law in any way, shape, or form. So if a law enforcement officer walks in there and says, hey, I'm here investigating Mr. McDonough who just got run over in the parking lot. Do you have video? And they say, well, let's check. And they check and they say, yeah, would you like a copy? That's up to them to give you a copy of that video. And so what the judge is saying here is, when they went to this lab that they have a contract with, they weren't asking for anything other than, can you give us a hint, a tip as to who this may connect to? And he points it out here. The Idaho State Police delivered Q1 to Orthram on November 22nd. Orthram developed an SMP profile from Q1 and searched family tree DNA and GEDmatch Pro. This work revealed 4 brothers of interest. So now we know that it was from a public database that allows searching, and what they came up with is 4 brothers of interest in a family tree somewhere. I love this stuff. That's cool stuff. But they break it down here. All of whom were low matches to the Q11. To further its family tree building, Orthram asked the state police to contact one of the identified brothers to provide a DNA sample to upload into either of the 2 databases. Despite Idaho State Police request, the contact brother declined to provide a sample. So here's the question. Who's that? Who is that? Is that, obviously, it's going to have to be somebody in the family tree somewhere, but it doesn't necessarily mean he's directly connected to BK. He could be a distant cousin, a 4th cousin, 2nd, 3rd, 4th. I mean, it could be 5 generations down. What they wanted to do was narrow that search by asking this person, hey, can we take your DNA? And in this case, the guy said, no, you can't have it. And guess what? They didn't take it. On December 10th, so had they taken it, the judge would have had a major issue. They would have had a major issue. And Ann Taylor may have won if they would have forcefully taken it or tried to get a search warrant, because they didn't have enough, to say that this person is connected to the crime. All they had was a low probability that this person, okay, is in the same genetic tree as the possible perpetrator of killing these 4 victims. On December 22, December 10th, 22, members of law enforcement, including the FBI, had a meeting to discuss Orthram's work. As a result, the decision was made to turn the IGG work over to the FBI. And what those meetings are typically, they go something like this. Okay. Hey, we have more resources and availability to break this down even further. Would you guys be okay turning it over to us and letting us see if we can develop a better profile? And it is one sentence. As a result, a decision was made to turn the IGG work over to the FBI. So they said yes. And notice that same day, December 10th, Orthram was instructed to stop work and turn over its SMP profile and search results to the Idaho State Police. Orthram did so along with the preliminary reports of its findings. The preliminary report did not contain any medical information associated with the SMP profile, i.e., Ann Taylor, your argument is hollow. It doesn't exist. Okay? The Idaho State Police then turned the information over to the FBI, i.e., chain of custody, which was able to use Orthram's profile to develop a significantly larger SMP profile. The FBI uploaded the larger SMP profile to multiple genealogy databases, including GEDmatch and MyHeritage, which purported to disallow law enforcement searches, i.e., you were arguing they don't let you do that. Well, yes, they do. Okay. At the time, the FBI had an interim policy issued by the United States Department of Justice related to IGG analysis and searches by its own agencies. And then he cites the order. On the one hand, the interim policy requires that investigative agencies conduct IGG searches in genetic genealogy databases permitted by law enforcement use. However, on the other, the interim policy also stated it was intended only as an internal guidance and did not impose any legal restrictions on investigative agencies, meaning here's the policy. It is not intended to, does not, and may not be relied upon to create a substantial or a substantive or procedural right or benefits enforceable at law or in equity by any part of the United States or its departments, agencies, entity, officers, employees, blah, blah, blah. The interim policy does not impose any legal limitations on otherwise lawful investigative or procedural activities or techniques utilized by the Department of Justice or limit the choices or decisions available to be made by the department at its discretion. What they're saying is, and I'm going to give you a very simple example on how to understand this. Mr. Jones, yes. Did you see what happened? Well, no, but I did find this here, officer. Okay. This found, we just used me, the glove out front. When Karen and I were standing there, we looked down and we go, hey, that's a glove. Okay. Officer, that's a glove. He walks over and picks the glove up and goes, or, they collect and go, by golly, that's a glove. Okay. That goes into evidence. Whether it's anything at this point, we don't even know the glove that they're citing, Ann Taylor, is the glove that I found that day. Nobody knows. I don't know. I'll know if I get a subpoena, and you'll know if I put my hand up in court. Yeah, I found that, I saw that glove, and the cops collected it, there it is. But in this case, what they're saying is, basically, you're giving a tip. DOJ is giving a tip to law enforcement. And look, he even says it right here, down at the bottom. The FBI instructed that the identification of a defendant as a person of interest was to be considered solely as a tip. It's like somebody calling on the phone. But in this case, they have 4 brothers that could be in this game, and then they narrow it down a little bit further, and then they hand it back to local law enforcement and says, well, here's a tip, here's a lead, follow this, because we've narrowed it down a lot better because of our lab techniques. Okay. So here it is. See what you can get out of it. Okay. No warrant was obtained for the FBI's work. Well, no kidding. They're both law enforcement agencies. You don't need a warrant to work with another law enforcement agency. That's why the FBI is there. Okay. You have to hand it to them. Okay. That's what this is. It's like somebody walking up, like I said a moment ago, and saying, hey, I found this. And you say, oh, okay, thanks. Okay. In this case, it just happens to be LE who says, hey, remember the stuff you gave us? Yeah. Well, we found this. Oh, wow, what is it? It's better than that. Here you go. And what did they do with this? As the investigation ensued, law enforcement discovered the defendant had driven from Pullman, Washington to his parents' home in a gated community in Monroe County, Pennsylvania. At this time, Monroe County Municipal Waste Ordinance required homeowners to dispose of their garbage by placing it out for collection or delivering it directly to a licensed waste hauler. Only an authorized trash collector could collect garbage left out for collection. So what they did is because it's probably a gated private party, but once it hits the curb, it's free. That's called abandoned property. Once you put your trash on the curb, law enforcement can drive by in the middle of the night. If it's sitting there, it has to be, you can't lift up the lid and start pulling stuff out. Okay. It has to be in plain view, but you can take it. But in this case, because there was a rule, they even followed the rule. And what they did is they made contact with the local trash collector to isolate and turn over Kohberger's garbage. So they let them collect it. And then they went to them probably a block away and said, okay, here's my trunk. We're going to put all that stuff in here. And that's what they did. Police work 101. That's gumshoe 101 right there. That's some good stuff, man. That's some great stuff. So they followed the rules. They made the arrangements with local trash collectors to isolate and turn over the Kohberger's garbage to law enforcement for testing. Articles of trash were retrieved and sent to the Idaho State Police forensic labs to conduct standard DNA testing, i.e. chain of custody. Keep it chain of custody. A DNA profile developed from one article of trash was determined to be from the biological father of source of Q11. So they measured it. And they said, hey, in our world, your phone would ring and it'd be the lab. And the lab would say, hey, Mac, are you sitting down? Yeah. Okay. We got a hit. Oh, awesome. What do you got? And then they tell you. Okay. Another article of trash revealed a mixture of male and female. According to defendant's expert Gary Schultler, PhD, the male DNA from the mixture was consistent with Q11 profile. And then they cite a law here, or when he testified. Importantly, defendant has not claimed ownership or knowledge of the knife sheath from which Q11 was taken. So had Kohberger said, yeah, that was my knife sheath, she would have had a stronger argument to go after this. But here, the judge points out very clearly, your guy didn't claim ownership on that knife sheath. After obtaining a search warrant, law enforcement collected DNA from a buccal swab obtained from the defendant. You notice he puts in here search warrant for the buccal swab. A traditional STR DNA comparison was done between the Q1 profile and defendant's DNA. The comparison showed a statistical match. Specifically, defendant was 5.37 octillion times more likely to be the source of Q11 profile than an unrelated individual. So that means, I think that's probably like 80 zeros, 40 zeros, I don't know. That's a lot of zeros. That's his DNA, folks. You're going to have to put him with Elon Musk, and they're going to have to go to Mars and look for somebody other than Bryan Kohberger for that DNA. Okay, this is an O.J. Simpson problem here. Okay. So the conclusion of the law, right? The Fourth Amendment, the judge points it all out. You know, he cites all the case law that was cited by, you know, the defense. And then in A here, he says, defendant has not established a Fourth Amendment violation with regard to the development of the SMP profile. So the judge has ruled saying, nice try. Unfortunately, you don't win on that one. So the Fourth Amendment argument is out on the profile. Then he goes down here and cites more case law and how it, measures up against defendant abandoning any private interest in his DA, but disclaiming knowledge of an ownership of the sheath, meaning, hey, the moment he said that wasn't his or doesn't given us indication, then he doesn't own it, and therefore he has no expectation to ownership of that or expectation of privacy. So therefore, in one here, he says defendant cannot establish a subjective expectation of privacy in the DNA found on the sheath due to abandonment, meaning it's just there. Your guy says it's not his. You can't show me that it's his. So therefore, I have to follow the law. And that means the law says voluntary abandoned property prior to a search cannot be said to possess the requisite privacy interest under the Fourth Amendment. And then he cites Stark versus the state, and that's the law. So the judge again says, hey, your guy says this isn't his. Okie dokie, not a problem. So he then gets down here about the arguments of the trash, etc. He says, no, abandoned trash, DNA from trash discarded by the defendant, which matched the DNA profile at the scene. Sorry, that's not a problem either. They did it right. And so ultimately he gets down to the ruling, and that most of this is just case law that he's citing to show, why he's making the decision that he's going to make. That's all. Even if abandoned, defendant has not established his subjective privacy interest in his DNA is objectively reasonable. Meaning he had to show them, the defense had to show the court that he had a connection somehow, and therefore he can argue, or they could argue that, look, that's a violation of my Fourth Amendment right. Okay. But there's no evidence of that he stood up, or the defense stood up and said, okay, we'll take custody of the sheath and tell you, yeah, at some point my client had that sheath, but we don't know how it got underneath the victim. Somebody must have stolen it, and then they could have come out with sod or some other theory on how the sheath got underneath the victim. But in this case, he never did that. And that's what the judge is saying. Had you done that, you would have had a stronger argument. But that's not what happened. They distanced themselves, quite frankly, from it all. And this is all the case law that he, starts to cover here. And I'll let the attorneys on other channels break into all of this stuff, in terms of the legal implications and what a lot of this means. But it's just legal, discussion here. So let's get down here. B, He said, defendant has not established a Fourth Amendment violation with regard to the trash pull and testing of DNA. Okay. So he's telling Ann very clearly, C, defendant cannot establish the search of the genetic genealogy databases implicated his Fourth Amendment right, i.e. violation. No, you haven't done it. I'm sorry. Defendant cannot demonstrate a reasonable expectation of privacy in common segments of DNA a relative has uploaded to the public sphere. Meaning, if I uploaded something and my cousin had committed a crime and they found my DNA, can they use my DNA? And the answer is yes, because I voluntarily uploaded it. So there's no expectation of privacy. The moment I did that, it was over. And that's what the judge is saying. Look, your guy can't prevent his cousin from uploading information, and therefore it's in the public arena, meaning he's standing next to somebody getting his picture taken. Well, don't stand next to that guy because you're going to get your picture taken. And that's what the judge is saying here. Okay. So therefore, to invoke the exclusionary rule to suppress evidence under the Fourth Amendment, a defendant must establish that his own personal rights were violated. And what the exclusionary rule is saying, look, my rights were violated. My rights. Okay. That was my sheath, and it should have never, ever, that information should have never, ever been out. So the judge could rule, okay, well, we're going to exclude that to trial. And that's the exclusionary rule. And now we go down here. This is getting to the really good part. This is all great stuff for the families. Defendant has no bias to challenge law enforcement's alleged violation of its own policies and those of the genealogy databases in conducting the search, i.e., Your Honor, they talk to the FBI. And the judge is basically saying here, and what's the malfunction? They're both law enforcement agencies, so therefore you can't challenge a violation of their own policies. They have no policy that says, once you get evidence, you can't share that evidence with another law enforcement agency. That's it in a nutshell. That's what the court was saying. And I mean, you got to give her an E for effort. Okay. But then he gets down here and says, conclusion. Based on the foregoing, the court denies defendant's motion to suppress genetic information. It is so ordered. I love this judge. Okay. Ruling number one, that was a big one. Genetic information. Guess what, ladies and gentlemen, friends, neighbors, TIR members, family members, it's all coming in. All of that DNA that they found is coming in. It's going to be put on, and it's going to be a show. There were 25 experts, disclosed by the prosecution, and Taylor is challenging 22 of them. 22 of the 25 she's challenging. Okay, so let's go to the next one. This one is the apartments and all of the information discovered in Pennsylvania and in Washington. Now, the interesting thing about this is, why did they want to suppress all of that in there? I'm going to submit to you guys tonight. Tell me what you think, but here's where I'm going. Okay. The reason they grabbed that TV is because they knew there was something on there. And remember, one of the warrants that I talked about earlier, almost a year ago, was this warrant on intrusion expert. They brought in this guy who's now working on a Secret Service task force. And this guy, they did a search warrant on this company, and the company provided them some information. And I have always wondered about, had he been sitting in the back in that parking lot back there with his knowledge of technology, Had he gotten into their Wi-Fi system, and if some of these guys are very capable of hacking your Wi-Fi and your computers in your house, your TVs, they can actually watch you. Okay? They can actually watch you. And remember the one woman who reported that she got spooked and Bryan wanted to help her. Okay. I've always wondered, remember he went over to her house and installed cameras and that kind of stuff. I've always wondered if he wasn't utilizing that TV at his house as his window into, really weird things, right? It's pretty creepy. It's pretty creepy. But why would the defense go and take his smart TV out of his apartment so fast? Why didn't the family do that? The defense investigators went over there. So I don't know. Do you guys? I'm sure you remember, that one woman who said, "Yeah, he set up some cameras for me in here," and I have always wondered if, in fact, the reason they brought in this intrusion guy was to see, and they put a search warrant. I did a whole video on it. I can't remember what the name of the video is, but it's in my playlist. And I showed what search warrant, what they took from the apartment that day. And in this motion here, she wanted to suppress everything that was collected, not only in Pennsylvania, okay, but she went after all the apartment warrants and Idaho warrant to search not only his person, but his property in there. So the judge, again, here he gives an introduction, and then he says, okay, well, what's the standard of the law? The power to assess the credibility of witnesses, i.e. that's his. And he tells that all falls within the court. And here's all the motions, here's the motion to suppress AT&T, Google, USB, Apple, Amazon. Why are they trying to suppress all of this stuff? Okay. So again, they're going after the, procedural methods of how this stuff was collected, And here, he lays out the investigation. He lays out the murder. He lays out where he lives in Pennsylvania, and that the Moscow Police Department requested assistance in their investigation, specifically in obtaining search warrants. PSP, Pennsylvania State Police, reviewed reports and affidavits prepared by the Moscow State Police Department, including a probable cause statement prepared by Detective Brett Payne, outlined the circumstances of the crime and investigation to date. Now, the reason ahead of that, the court laid out, look, my standard, i.e. under the law, I have to measure the credibility of a witness, and then I have to resolve any factual conflicts and weigh the evidence and then draw factual inference. That's my job as the court under State versus Valdez-Molina. So what he told her right up front in this motion to suppress, it's my job. I will be the one that will determine whether the police are being honest or corrupt. That's what he's doing in this paragraph, because when he gets down here, he's also saying they're asking other law enforcement agencies for help because the suspect, i.e. Bryan Kohberger at that time, who was, a person of interest and definitely a suspect, they have the legal right to ask for help. There's nothing wrong with that at all. In fact, how do you solve a crime? I mean, I've asked the federales in Mexico for help in finding somebody in Varios down there in Central America and Baja and all this other stuff. So that's how you do it. And so what the judge is saying here is, look, all of these affidavits, 3 search warrants from the magistrates, they even went to magistrates in Pennsylvania, is what he's saying. Okay. And so as a result of that, he's basically, saying these arguments don't fit. Your argument, your fact pattern does not fit in relationship to what took place. Okay. How did it fall into place? Okay. So he lays it all out. Signed arrest warrants by the county magistrate, and then on the 29th, Pennsylvania State Police and its Special Emergency Response Team, or CERT, prepared for an execution of these warrants. Detective Payne was briefly present and observed the final preparations, but then departed to prepare for defendant's arrival at the PSP, Pennsylvania State Police Station. It was Detective Payne's understanding the PSP and CERT were preparing for a knock and announce entry. During their final preparations, snipers set an umbrella around the residence to monitor activity therein, while a helicopter monitored the overhead event. Defendant exited the defendant exited the residence. Now, think about this. She made a big deal out of them kicking in the door. Okay. Well, she's lucky she wasn't in LA. I mean, I can't tell you how many search warrants. We did 4 search warrants one time in South Central, and LASD, used the hooks on the doors because they have every window and every door in every house in, that part of the neighborhood had bars on it. And so we just ripped the doors off. I mean, the whole front of the house came with it. And then, you would announce, police with a search warrant, throw a flashbang in, and the SWAT team would go in and clear the house, secure everybody, and 10-8. Especially when you have a person that's killed 4 people. 4 people. Okay? You can bet somebody behind the house would have done a diversion, breaking the windows, and, we call it the BFT, the big frickin' truck, would drive up, and one of the SWAT guys would hook a hook on that front door, and you'd give the announcement. And if no response, man, that door is gone, and probably the front of the house. I mean, literally, I've seen door frames, everything come with it. And I had a laugh one time when she was like, blah, 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 arguing that the police use excessive force. No. They use reasonable force, with the understanding that there was a person in there who had potentially murdered 4 people. Okay. That's a real problem. Okay. That's a real problem. So anyway, the same person was seen again. A white male wearing a black hoodie standing near the glass sliding door leading out to the deck at 12:40 a.m. The same person was seen again. So he's looking outside, is what I'm reading here. Cops show up. He's peeking out, pizza man, we're here to deliver pizza, at 12:40. The same person was seen again. This time, officers were able to positively identify the person as the defendant. The light turned on in the garage where defendant's vehicle was believed to be parked at 1:03 a.m. So they were very patient. They see him out on the deck, 12:40. They see him peeking out at 12:55. The light comes on in the garage at 1:03. Lights flashed in the garage as if the vehicle was being locked or unlocked by a key fob. At 1:09, a defendant was seen in the kitchen at the home, that this time wearing rubber gloves and handling a plastic baggie. Okay, 1:09 in the morning, everybody puts on rubber gloves unless he's doing the dishes. But unfortunately, he's walking around with a plastic baggie. Based on these observations, law enforcement believed the defendant was potentially destroying evidence from the vehicle that was related to the homicides. Okay. Law enforcement was also where the defendant possessed a Glock handgun. Now your officer safety goes up a little bit higher. Actually, a lot of bit higher. Okay. Why, now knock and notice may not even be necessary. If you had information, direct information that he may be armed or had possibility to be armed, then you can just, tear the door off and go on in and say, good morning. Defendant possessed a Glock handgun, prompted a concern over officer safety. Boom. Defendant's heightened mental state of awareness or threat level of police possibly tracking him. Thus, law enforcement made the decision to shorten the knock and announcement when executing the warrants, just like I said 30 seconds ago. That's exactly what they did. Okay? That's exactly what they did. So they hit him at 1:14 in the morning, 01:14 a.m., made the announcements from a Bearcat, that's the BFT, the big frickin' truck, okay, parked in the driveway of the residence. I mean, that's pretty obvious, looking out, can you imagine? Hey, Bryan, they're here. Hey, they're who? The big frickin' truck is here. I think they're asking for you. Immediate following announcement, a forced entry into the residence. Defendant was arrested without incident in a bedroom. So the question is, did he run from the kitchen to the bedroom, in my head? His vehicle was located and secured in the garage. And once apprehended and handcuff was placed, he was placed in the vehicle. He was notified that he was in a police vehicle and being recorded. And audio recording. So now we know he was put in the back seat of that car and he was told, hey, you're being recorded. While awaiting transport, defendant informed law enforcement that he had an unloaded Glock 22 handgun in the residence by his bed. During transport, defendant engaged in small talk with the accompanying officers. By the way, this is all recorded now. We know this. So he's chit-chatting. When defendant expressed at one point that he wanted to know what was going on with his arrest, law enforcement told him investigators were going to speak with him at the station about the situation. Now, in a situation like this, when you first put somebody in custody and you put them in the back seat and they just start chipping away, okay, let them. Don't say anything. Don't read them Miranda, nothing, because that's all considered spontaneous statements. As long as you are not soliciting information that will be incriminating to them because they're in custody. And if they start saying stuff like, don't you guys want to talk to me about that case or blah, 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 you have to, by law, have to stop them and say, look, I can't talk to you until I read your Miranda rights. You're in custody and you're starting to say incriminating statements. So I can't do that. So we just hold on. But in a situation like this, where you just keep your mouth shut and he's just chipping away, saying, hey, man, there's a gun by the side of my bed. You don't say anything. You get on the radio, you get outside and you say, hey, go check the gun by his bed. Told investigators was going to speak with him at the station. The details of the investigation were not disclosed. Once they arrived at the station, defendant was escorted into the processing room to wait for an interview with the detective, Payne, which occurred 10 minutes later. He was then informed of his Miranda rights. The two issues before the court, whether law enforcement failed to comply with knock and notice, that's what it's called, knock and notice, whether defendant's post-arrest statements were suppressible as fruit of the poisonous tree or due to a Miranda violation. Okay, guys, so this is really good stuff. This is the first time we're hearing this. Apparently in that car, and they have it on tape, he was talking about something. Okay? And when they got him back to the PD and they put him in the room, 10 minutes later, the detective Payne goes in there and reads, cuts him Miranda. Okay, cuts him Miranda. So I want to know what that tape's going to show in trial. Maybe this is where the idea had come up where, he was asking questions. Had anybody else been arrested or something to that effect? I don't remember exactly. Do you guys remember hearing that, kind of floating around somewhere? But defendant's statements are not suppressible since there's no poisonous tree and because he's not demonstrated any incriminating statements were made while under interrogation. The state is correct. The judge ruled on that. Law enforcement did not violate defendant's rights in executing the Pennsylvania warrants. Boom. Ruling number one. And then they get down here, the knock and notice. He points out exigent circumstances, which means emergency circumstances, existed, i.e. there could have been guns in the house, and later they discover, yes, in fact, there were. He tells them that spontaneously in the back of the car. So the warrant, the reason the knock and notice was expedited, and the judge points it out here, because exigent circumstances existed, i.e. somebody could have been killed, the defendant, an officer, a family member. Those are exigent circumstances. That's where you get to the door and you hear somebody on the other side of the door and they're beating the tar out of their family member, and you look through the window and sure enough, that person's on top and they're choking them. Exigent circumstances existed. You can kick that door in and go save that person who's on the bottom getting choked. In this case, you have him peeking out. You have him looking around. You have him in the kitchen with gloves, about ready to throw stuff. You have him going into the garage. You can't see what he's doing in the garage, but you see the car locking. And you're thinking, as a, common sense, is this guy destroying evidence? What's going on here? If he's our guy, we can't let him do that. So now it goes up. And that's what the judge says here. The court further explained that exigent circumstances could include those immediately circumstances where defendant may be armed, where evidence may be easily and immediately destroyed, where defendant may escape, or where defendant has engaged in furtive conduct, i.e., looking around, that kind of stuff. That's what that means. When you make a traffic stop and the officers put lights on your car and, you start reaching underneath your seat, that's furtive movement. And that's very dangerous in law enforcement, because these things here, these kill. These things take your life. Hands. Somebody else's hands can take your life pretty quickly. And so that's what the judge is saying here. Look, I find that there were exigent circumstances that existed. And so then he states the law, and then he goes down here. Here's his decision. Emergency excuses law enforcement from compliance with knock and notice announcement. So exigent, man, my lisp, sorry. You guys know what I'm talking about. It existed. Exigent circumstances existed, and they could get in. So therefore, it was an abbreviated knock and announce. We call it knock and notice prior to entry to the house. So because they were worried he was destroying evidence, like they said. An officer, look here where he says, would have placed the officer's safety in jeopardy. So those are true exigent circumstances. He notes that he was surveilled by law enforcement prior to the warrant. That's Ann Taylor talking. And he now cites the law as to why the decision he had just made. Okay? About that. Destroying evidence, time of morning. Defendant has not established he was interrogated when he made unidentified statements. So let's go back here. He said something that caught their attention. And they were like, let's see here. I thought he had made a comment, I thought I read in the news something like, am I the only one arrested? Or something like that. And if he had made that statement, well, guess what? That's actually a plus for the prosecution, especially with the new DNA blood. If he made that statement, then it's the defense that has to prove there aren't two outstanding suspects. The prosecution doesn't have to prove that right now. For all we know, they're still investigating a possibility, but they definitely know they have one, and that's Bryan Kohberger, allegedly, as the suspect here, but his DNA's there. So they have to show that that DNA got there somehow by these alleged, ghost people. And if that's the case, and he said something like that in the car, that's a win for the prosecution. That's a win for the prosecution. Because that means they got one of three, hypothetically. That's how it will be argued. But you and I all know, we all know, common sense tells us there isn't anybody. There's not Assad, some other dude. He doesn't exist, or she doesn't exist. You can forget it. You have an eyewitness at the bottom, Bethany and, Dylan, who goes, there was one guy, or Dylan goes, there was one guy. That's it, period. That's all I saw. I didn't see three people in the house. Okay? And if she was drunk or something to that effect, it doesn't matter. You don't really need her testimony other than put her on the stand for one question. And here would be my question if I was the prosecution. Were you in the house? Yes. Did you look out the door? Yes. How many times? Multiple. And what did you see? I saw a guy coming down. He appeared to have bushy eyebrows and he was wearing a mask. How many did you see? One. No further questions. That's it. Done. 10-8. All units cleared. Move on. Something else to see. Okay. And so anyway, he goes, the judge gets down here. He lays out to defendant has not established he was interrogated when he made statements under Miranda. Let's see here. So here's his conclusion. Based on the foregoing, the court denies the following. Defendant's motion to suppress the search warrant, the Pennsylvania house. Defendant's motion to suppress arrest warrant and search warrant on the white Honda Elantra. All of that is coming in. Anything they found in that Elantra, anything they didn't find in that Elantra, all of that is coming into court now in the trial. It's all going to be there. Thank the Lord for the families. It's all going to be there, and we'll let both sides. It's going to be one doozy of a court trial. They're going to argue. Defendant's motion to suppress search warrant of Mr. Kohberger's person, i.e. the buccal swab, that was kind of, she snuck that in there, okay? She snuck that one in there. That was a secondary one. She attacked it from the DNA, and now she attacked it at the house, because that's probably where they got some DNA additional stuff on him. Defendant motion to suppress search warrant for Mr. Kohberger's person. Defendant's motion to suppress search warrant for defendant's apartment. Why would you want to suppress that one? He's not involved. Right? Isn't that their argument? He was out, driving around the park, just looking at the stars, looking for Elon Musk, just enjoying the evening, and he accidentally happened to turn his phone off while he was doing it. Oh, did I tell you, Your Honor, just before the murder, he turned his phone off. Stargazing. Exactly. Okay, before we get in the third one, let me grab some of these memberships. Thank you guys so much for being here tonight. You're amazing. We love you guys. Thank you so much. Thank you for being members with our channel here. We are so appreciative. Yeah, let's hope, under your scars, let's hope that he is now realizing the death penalty is on the table. It is on the table. Okay, but it's not the last of this, by the way. We'll hear some more arguments, don't you guys think? Thank you, Kimmy. Don't you guys think we'll hear more arguments here coming up? Thank you, Kimmy. You're so kind. Okay. Let's see here. We only got two more. You guys are awesome. Thank you so much for being patient with me as we went through this together here. So grateful. Thank you. Okay, so let me keep going here. Hang on. Sorry, guys. Okay, the next one. And this is one of my favorites. With the IGG was probably my favorite. And because that in of itself, man, had they gotten that one kicked out, whew, it would have been fun in River City. But I love this one because, that I'm convinced that Amazon is going to be really, really crucial. So stepping back for a moment, 30,000 foot view. All right. What mistakes do I think early on we saw? Well, the most obvious one was, working the crime scene from outside in. Okay. Now, that doesn't mean they did it wrong or inappropriate or anything like that. No, but I can see the defense arguing. Okay. The fact that when I got up there, Karen and I on Thanksgiving Day and we looked down, there's a glove. I can see the defense arguing that procedurally, they had screwed up some things. That's the first. So it won't surprise me if those types of arguments are going to come in the trial. Okay. The second piece is the house. The house is gone. That's going to be, in my opinion, now that this is on the table, Anne is going to turn that against the prosecution, even though she signed off on it. Okay. Thank you, Calcola. Even though she signed off on it and the prosecution signed off on it and it was pushed through by the university, now she's going to argue, well, there was exculpatory evidence on that handrail, i.e. blood, to an unknown male. It's not my guy. Your Honor, we don't have that. We don't have that. Okay. So during the trial, I can see a curveball like that coming in from the court, to the court, another motion. But this Judge Hippler, I mean, this is not his first rodeo. He's been around the block a couple times, and I think he's just going to say, no, I'm not sure about that one. But we'll find out, right? We're all going to be there when this thing goes down. So this motion here is AT&T, Google, USB, Apple, and Amazon. Okay. Why this one, right? She was trying, and again, this is, the judge laying out what the circumstances and totality of the circumstances were, and who he listened to. The court finds suppression is not warranted because one, defendant relinquished any privacy interest he had in the record subpoenaed from Amazon and Apple pursuant to the third-party doctrine, and two, the remaining search warrants are valid. So once you sign up with a carrier, remember all those terms of services that you check, okay? Remember all of those when you buy something from Amazon or you open an Amazon account and you click, these things, blah, blah, blah. That is what you call a third-party doctrine. So because you have done that, because we have all done that, that means the police, if you have a lawful reason to go after that information, then the terms of that company, they have a security division, and they actually have a fax machine that you can fax directly into the security, and it goes, oh, we'd like the search history because the court has ordered it for the law enforcement. We'd like the search history on everything Amazon had from one account, i.e. Bryan Kohberger, yada, yada, yada. They go into their records and they look and they go, oh, yeah, he opened the account here. Yep, check that box. Valid search warrant, i.e. number 2. Okay, valid search warrants. Yep, we're going to give it to you. Thank you very much. And again, the judge will make the decision, same standard he has. Findings of fact, he's laying out what happened. Okay. But here we learn that the investigation ensued after the bodies were discovered. Each appeared to have been stabbed. The investigation that ensued was a multi-agency affair involving members of the Moscow Police Department, the Idaho State Police, and the FBI, among others, meaning there are more. There are more. We don't know who they are yet. Could be Secret Service. Remember that guy I was talking about. Okay. For the purpose of the investigation, a command team consisting of several investigators from each of these agencies was set up at the Moscow Police Department. The command team included, i.e. a mini task force, Detective Brett Payne, Detective Mowry, and Moscow from the Police Department, as well as Special Agent Nicholas Balance of the FBI, all of whom were co-located on the second floor of the Moscow Police Department. The command team met twice daily for several weeks to review, analyze, organize the information gathered in the investigation. Pertinent information was transmitted into a working probable cause affidavit that could be and was incorporated by law enforcement in the various search warrants affidavits. So what the judge is saying here, there were a group of law enforcement officers, a mini task force, for lack of a better term. As relevant information came in, thousands of tips, the relevant tips that were most logical were sent to the investigative team. The other tips, typically what ends up happening, remember when all those cops started showing up, during the first week or two? Okay, these are the tips that say, hey, there was a sighting of, Kaylee over at the ice cream place. Run that down. Okay. Hey, there's this. Hey, is there? So all of that stuff that they knew, they saw them on the grub truck video, all the other stuff that's irrelevant, but you don't know until you check it out, that goes to the other folks. And that's what the judge is saying here. Look, all the relevant stuff, the command, they met twice a week. Pertinent information was transmitted into a working probable cause affidavit, i.e. information the law enforcement knew was solid. The car, the phone, that kind of stuff. Okay. So how did they get all that information? Well, they had to serve these search warrants on everybody. Apple. They also did a pen trap and trace, which is, a trap and trace. Typically, they're at the FBI, unless you're a larger agency. So they have these. It's basically listening, inbound, outbound, and all this other stuff, and it's good stuff. So they had a warrant. There's a company called Penlink, is probably who they used. And the cell phone expert, they had Agent Balance, who was a member of the CAS team, the FBI Cellular Analysis Survey team. Okay. This is why the defense expert, Cy, testified when he did testify. Well, I have to reserve judgment because I don't have all the information, all the data. I need data. And this guy had all the data, Balance, okay, from the CAS team, and specialized in cell records analysis. So what he did was they got all their information, probably from the phone dumps, and they stick it into a software program, and then you're able to analyze that information. The FBI even has a program, and I've talked about it on this channel before, called Gladiator. And it's unreal. So don't be surprised in the trial when he testifies if we're not nailing down almost to the location specifics. So this generalization that Ann Taylor was trying to say, well, we can't tell if it's going or if it's coming or whatever. Well, in some cases that's true because those cell towers are triangulated, okay, and you don't know if the signal's coming in here. Okay, great, you capture that signal, but when the signal passes, then guess what? You capture it from this side too. So now the question is what's in between? And that's where these other softwares come in. Okay, so she was talking about generalities when this guy here from the CAS team and the FBI, remember they put the guy who killed the children in Idaho in the backyard, Alex. They put him in the backyard by the doggone fire pit. Okay? That's the type of information you put your seatbelts on. It's coming. It's going to be coming. And she knows it. Ann Taylor knows it. And so what was she trying to do? She was trying to suppress the AT&T warrants, because if you could suppress the information coming in, then you could suppress everything else. So she argues here, customer subscriber information, device purchases, yada, yada, text messages. She wanted it all crushed. Okay. Even on the, second, they did a second warrant because when they got some information back, they had questions about it. So they sent a second search warrant and said, well, we have questions about this. Can you answer this? And the AT&T sent them additional information back. This is the pen trap trace warrant. This is, what I was just talking about, the registration and trap and trace numbers. So they were on this guy, and they were on him deep. And here was his statement of affidavit. The judge just points it out. The pen trap warrant, Google, they want to suppress anything that he may have been searching, which we don't know because that information's not revealed yet. They got the information back. We just haven't seen it. The IMEI number, which is basically, the social security number for that phone, the identifier. The Google warrant, they want to request that or squash that. IP phone numbers, i.e., did he have Google, phone numbers? Was he using Google Voice as a ghost number? Each of the three warrants were temporarily limited to January 1. So the judge lays out here, he says, well, you know what? They're just not out fishing. They use a specific time frame. They went after that time frame. And guess what? They got the information back. And unfortunately, it belongs to your guy. So there's a problem here in River City. And so she tried to suppress all of that. Okay? Even YouTube registration. So this will tell us if this is Papa Rogers or not. They know. That information came back. They know. Okay? They know. These warrants were each supported by a search warrant affiance executed by Detective Mowry, and we saw him testify recently. They were just like, yes, no, yes, I'm not sure. I'll have to look. All they had to do was a probable cause hearing just to get it through. The USB, whatever is on this USB, she wanted it suppressed. Books, letters, data, anything on there. And so that tells us they stuck it in maybe a computer and downloaded as much as they could before they put it into evidence. Apple warrant, meaning, what's on his Apple account, right? It was locked. Anything associated with it. What they want to do there, obviously, is to see if there's any correlation for the intrusion stuff there. I'm still, his iCloud account. I'm still convinced. I don't know. It's just my personal opinion. I could be 1,000% wrong. I just wanted to know, was this guy sitting in the back of that house? And I'm going to submit to you, I believe he was for quite some time. I really do. And, his phone pinging over there as many times as it did, that's problematic. Amazon, this is going to be the knife sheath. When you look at that ASIN number from Amazon, which is the inventory control number, I did a video on that. And it just so happens the number that they have on the return is the exact same number you type in, and it comes back to a K-bar Marine Corps knife. So we'll see where that's going to go. So the judge says, okay, here's my conclusion based on the law. Okay. Defendant does not have a privacy interest in subpoena records protected by the Fourth Amendment or the Idaho Constitution. The subpoena did not violate defendant's Fourth Amendment rights. And then he breaks it down even further. He gives the case law that he's citing and why he's citing that. The court is limited to holding a carpenter to the facts before it, i.e. that's just case law. Okay, meaning are the facts in Carpenter consistent with the facts in Kohberger case, People versus Kohberger? And the judges, he took that into consideration. And all these were presented to him pretty extensively by the defense, which is their job. Okay. And then what he's doing is he's saying, well, look, there are different fact patterns here in People versus Carpenter versus People versus Kohberger. Same thing under People versus Miller. Okay. Under Miller, the security footage of him shopping and the transaction records could be obtained without implicating the Fourth Amendment, meaning the judge is citing the law that why the police could do what they did. There's a case law that says they could go into that convenience store and say, we'd like to see. Now, this is interesting. It tells us right here there's security video footage of him shopping. So they got him on video shopping. This is all new stuff. This is great stuff. Okay. In visiting defendants' affirmative acts in visiting Amazon website, shopping for items, placing them in a shopping cart and arranging for delivery and payment. So he did something that she did not want out at all in any way, shape, or form. And there's also somewhere on security footage where he's doing more shopping. Maybe this is buying the clothes. We don't know. We're not sure. But we definitely know there's security footage because the judge cited it. The fact that he was in a virtual store does not change the analysis. Oh, okay, I see what he's doing. Okay, I'm wrong. The judge is saying, look, if the cops had gone in and gotten videotape of him shopping in a real store, there's no difference than them going in and getting this information from a virtual store. So I stand corrected here. I stand corrected. So that was the analysis that he was using. Under Miller, there is no difference. In addition, any subjective expectation of privacy, he may have had it with his Amazon purchase records and Apple subscription information is unreasonable given according to the policy cited by the defendant, i.e. he signed off third party right there, down there, right down there. But he could have bought stuff that we don't know yet on both of these because she was working so hard. No greater protection than the Fourth Amendment. He's now citing the law, giving case law as to why. He's not saying that they're, unusual. She had cited these cases and he's giving her a secondary argument. It's kind of like where he said, well, isn't that probable cause, 2 Sundays, et cetera, et cetera. And this is what he's doing here in written form. Electronic data can be hidden in multiple formats, phones, laptops, et cetera. So he's saying the defendant in the Georgia case, in the one she's citing Wilson, this is much different, much broader. And he cites his argument down here based on her argument. See, and he even says a broad language may be permissible when the warrant constrains the search of the evidence to be specific crime rather than allowing a fishing expedition. And under Bishop, and what he's saying is, well, narrow your argument. Okay, they're not fishing. They took your guy's information and they went out looking for your guy's information. That's all they're doing. They're not looking for 42 other people in the store under Bishop, which she said they were. That's not what the judge said. So we get down here, the AT&T warrants. Finally, we get to the end, the Apple warrant. The judge says, no, not a good argument. No. Google warrants, no. The search warrant affidavits provide probable cause. He makes that pretty clear here. Okay? That's basically the gist of what he says. And now arguments, the Google warrants are sufficiently particular, i.e. they're narrow in scope and they're for a particular, time frame, scope of information. Once they got information back, that scope changed. So what did they do? They went and got a second search warrant. And now that scope expanded. She argued, well, the scope that, the second one, she was arguing the second search warrant. Well, that's too broad. They should not have just gone on a fishing trip. And the judge says, no, they didn't go on a fishing trip. They went looking for your client's information. Once they got information back, they discovered there was more information out there. So that scope expanded. And rather than just going back on the first search warrant, they got a second search warrant to go back and get it. And that's what the judge is saying here. The USB warrant, any deficiency in the warrant's command to search is not a basis for suppression. So the judge is laying down the law here. In his conclusion, based on the foregoing, the court denies the following: defendant's motion to suppress AT&T first warrant, defendant's motion to suppress pen trap and trace device, which is probably going to be a pen link, defendant's motion to suppress Apple account federal grand jury subpoena and search warrant dated August 1st, 2023, defendant's motion to suppress Amazon account federal grand jury subpoena search warrants dated April 26th, May 8th. Now, here's an interesting thing. The grand jury saw the Amazon information. I can't wait. I can't wait to see what they saw. Okay? Because she did not, no way, did she want this Amazon account that was shown to the grand jury to be seen. This is really, really good stuff. That's really good stuff. Okay, so let's go to the next one, the last one. This is the Franks hearing. Okay, so what's a Franks hearing in the gist, right? What's the bottom line here? In a Franks hearing, if the defense alleges that law enforcement or their agents just lied about everything, and those lies multiplied themselves over and over and over again, okay, then the judge says, okay, well, let's have a hearing. And then you can argue what exactly your argument is in front of me and convince me. Okay? Because here he lays out, what the standards are. He is, okay, the Franks motion, the trial court determines whether or not representation is false and whether a misrepresentation or omission was made knowingly and intentionally, i.e., are the cops, are the FBI, Idaho State Police, is the university, are the families, everybody in totality, who's lying? And if it's the police, that's who they start with in a Franks hearing. If it's the police, show me those lies. Let's see them. Okay? Because it's my opinion, i.e. the judge, he's the one that has to measure what that means. And he's the one that has to say, you know what, you've made a point, Ann Taylor. Good job. Okay? So this officer will be, deemed incredible, not credible. And the law enforcement, there's what they call a Brady list. Okay? If you get on that Brady list, that tells the court right away, where the defense can raise, said, Your Honor, this officer's had a Brady motion against him. And that means he's been found or she's been found to not be reliable in a court of law. It's a very huge thing. It's a gigantic thing. Well, Franks motions are typically the catalyst to get to that point, to where you can argue, credibility of an officer and the standards of that officer. And you have to show certain things in court, before you can ever be voir dire as an expert. Okay? I've been voir dire as an expert many times. And trust me, they go through your entire record and they ask you your schools, your training, And if you've said that, you were A, B, C, or D, and it doesn't line up, okay, well, you could be subject to a Frank's hearing. If that's Frank's motion, if that's the case, they will tear you apart. They will absolutely tear you apart. Okay. And rightfully so. We don't want dirty cops. I don't want dirty cops. I want better cops. I want great attorneys. I want great defense attorneys. I work with great defense attorneys. I've worked with hundreds of them. I want great prosecutors because that's what balances the system. I want great judges. If the prosecutors are right and the judges are right and the cops are right and the defense is right, guess what? You get justice for these four victims. You get justice. Okay. So here the court says, okay, well, what's the analysis here? And the analysis is, or the argument was from Ann Taylor, well, the search warrants are valid because these officers didn't necessarily tell the truth, essentially. That's the gist of it, what's going on. So the court said, okay, well, I'm going to take everything into consideration. And that's where he lays out the law. Okay, a Frank's two-step process. The first step considers whether the defendant has made substantial preliminary showing that the affiant knowingly and intentionally or recklessly falsified or omitted information from his or her affidavit. And what was her argument? Her argument was, the DNA. Well, they didn't share all the DNA. Okay. Well, they don't have to. If you're looking for a warrant of arrest for Bryan Kohberger, that's all you have to share. If you've got two other suspects, like in a bank robbery, you don't have to put all three bank robbers on a warrant for that guy to get his stuff. Okay. What if you don't even know who those other two guys are, like this DNA? Okay. Does that mean the warrant that they got for Bryan is irrelevant? No. And that's exactly what the judge is going to say here. And he's going to argue, he's going to put it in paper and in his ruling and say, look, your guy has DNA on a sheath in the bed with the victims. Those other two guys, we don't know yet. We don't know who they are. There could have been three bank robbers, hypothetically. Probably not. It's probably going to be some party or something. Who knows? I don't know. I'm not going to speculate. But I'll tell you this. They know for a fact that it belongs to him. And that's where the judge sat back and he says, well, that's probable cause right there. 2 Sundays or whatever he said, if I remember right. Okay. So that's what this is. This motion was to have the defense bring their A game to show that the officers intentionally left out information that would have been exculpatory in nature to their defendant. Okay? So let's get down here to his ruling. Defendant has not met his Frank's burden on issues 1 and 2 challenges to Exhibit A. Defendant has not demonstrated anything improper in law enforcement's execution of Exhibit A based on collective knowledge, i.e. the knowledge at the time and the moment it was happening. Defendant has not established that alleged misrepresentations in any of the 3 challenge search warrants affidavits compels a Frank's hearing, i.e. I don't know what you're seeing, but everything that I'm seeing, I was later advised by ISP investigators that located the tan leather sheaths laying on the bed next to Mogan's right side. How are you going to get around that? There is no escape hatch for Kohberger at this point. The CAS team, he says, locations after consulting with the FBI CAS explain the respective affidavits that CAS was the FBI cellular analysis survey team. They were determined where this information was being located, i.e. the 12 pings. Defendant has not met his Frank's burden on issues 310 and eyewitness statements, i.e. DM. Well, again, we go into that concept of let's just hypothesize that she's polluted that night. She's drunk. She hears something, but she's not sure because she's drunk, or I don't know what the problem is. We don't know yet. We'll find out because now it's all coming in. But then the judge points out, well, okay, if you're going to do that though, but in her dream state, there was also video of what sounded like something going on from a camera 50 feet away. So even if the state doesn't use DM as a witness, which I would suggest they don't, they would just put her in there and, again, go back to the questions that I mentioned earlier, okay? Even if they don't use her, the judge says here, but her accounts were consistent and accurately summarized in Exhibits A. Okay? In this one, she made account or gave a statement about times she woke up, same time. And what the judge was saying is, yeah, they were consistent, but then he gets down here and says, however, in case they weren't, there was an audio which sounded like a struggle coming from off a camera. The camera was less than 50 feet from Carnoto's bedroom wall. The struggle lasted less than 1 minute, and unintelligible sounds can be heard on the camera. So now think about that. The struggle lasted less than a minute. This is, people have said, how can one guy kill 4 people? Well, it sounds like this struggle lasted just less than a minute. That's how he can do it. Okay. When you're overpowering and you're in that type of adrenaline is running, it probably took less than a minute to kill her. And that's what probably that video picked up. And that's what the judge is saying. Well, take her out of the picture. Take DM out of the picture. The state still has this other evidence that sounds like something's going on there. Okay. It's huge. She stated she opened her door the 3rd time, she hears crying and saw a figure clad in black clothing and a mask covering his mouth. He's described as 5'10" or taller, very muscular, athletic build with bushy eyebrows. The male walked past her as she stood frozen in a shock phase. As the male walked towards the backsliding door, she locked herself in a room after seeing this guy. Okay. Well, she can't identify him. You don't need to identify him. All you need to do, again, is put her on the stand and say, were you in the house? Blah, blah, blah. Yes. Okay. Tell us what you were doing. Blah, blah, blah. Yep. Okay. And did you see somebody? Yes. How many? 1. And what time was it? About 4 a.m. Okay. Did he have bushy eyebrows? Yes, he did. Was he wearing a mask? Yes, he did. Can you identify him? No, I can't. No further questions. And the defense can get up there and try to tear her up all day long. And I feel sorry for her. Now, because the question's going to be, well, what did you do, before you guys called 911? What happened? And we don't know what that answer is yet. We do not know what that answer is. Okay? That answer will come, though. There is no evidence law enforcement intentionally or recklessly omitted information bearing on DM's reliability or that such omissions were material to probable cause. So basically what the judge just said is the cops haven't lied about anything. That's what he just said. Specifically her. I.e., there's no conspiracy here. That's what the judge just said. And this is a judge in Idaho or in Boise, away from Latah County. So if he's in on it, okay, like a lot of these crazy concepts going around sometimes, he's just throwing himself into the pot here. I don't think this guy's like that at all if we watch him. So basically we get down here, DM does not recognize recognition defendant is immaterial, i.e. you should consider that a win. Ann Taylor, she didn't recognize your guy if that's your guy. Okay. So defendant has not met Frank's burden on issue 4, the vehicle. The cops haven't lied. The FBI specialist may have been more comfortable with a narrow date range that represent Exhibit A and unsupported and immaterial. He said it was an Elantra. He got at first he was a little bit further off on the date, or excuse me, the year the car was made, but then they narrowed it down, 2011 to 2016. Defendant has not demonstrated a false representation or omission with regard to identification of the suspect vehicle, i.e., the cop told you it's either 2011 or 2016. There's a range there. I'm not sure which one it is. They get it, and it's a 2016. Boom. He got it right. Okay. If it was a 2012, boom, he got it right. If it was a 2013, boom, he got it right. That's what the judge is saying. Okay. Defendant has not met Frank's burden on issue 5, misleading timeline. That's where he breaks into the surveillance footage, what time he left. Defendant has not met Frank's burden on issue 6, the dog barking, the security cameras at 417, nearby residents. I'll tell you that security camera is going to be big. It's going to be big. Said that a long time ago. Defendant has not met his burden on 7, the cell phone data. The geofence return assertion was not a false or misleading statement, i.e. the cops have told the truth. The FBI has told the truth. Challenge the timing of the second AT&T warrant is conclusory. Well, we know why they expanded the scope based on the other motion. Defendant has not shown the alleged misstatements regarding when defendant's phone stopped. Reporting was intentional, false, or exculpatory, i.e. why'd your guy turn off the phone? Why did your guy turn off the phone? You're arguing about all these other guys, and he even mentions here, defendant's cell expert, Cy Ray, contends he has reviewed multiple search warrant affidavits prepared, and his statement the defendant's cell phone stopped reporting the network 247 is blatantly false and not supported by the AT&T data. In addition, these two experts' affidavits defendant includes in his proffer the AT&T's call records that purportedly reveal the actual time the phone stopped reported to the network was 2:54. Okay. So he's got it 5 minutes later that the phone got turned off, but he doesn't have all of the data. And so he's not saying the phone didn't turn off. He's just saying the phone turned off at 2:54 versus 2:47, which is a 9-minute difference or thereabouts. But then remember when he testified, he also said, but I want to hold back because I don't have all the additional data that law enforcement does. All he had was what they had given him. Okay. But they don't have those reports at that time in that hearing. So he goes on here, the judge, to basically say everything you said, defendant has not shown any omissions regarding cell tower coverage area was reckless, intentional, or material, i.e. that the cops, covered something up. Defendant has not met the burden of footprints outside DM's door. I mean, she argued everything. Grand jury subpoenas, lack of connection between defendant and victims. Now, here's an interesting statement. However, defendant has not established a lack of connection was fact conclusively known to law enforcement at the time the search warrant applications were submitted. Thus, he cannot establish it was intentionally or recklessly omitted. The omission was not material or exculpatory. So what the judge is saying here, well, you haven't shown us proof that they knew there was a factual basis, there was no way that there was a connection. So what the judge did here is he left it open, I think. Looking at this, he's left it open. So maybe there is something connecting them. We don't know yet. Maybe there is something in there connecting them. But what he just told them was, well, you guys haven't established it. So Meaning go back to the sheath again, remember? The same principle. Well, if you're saying it's his sheath or not saying it's his sheath, which one is it? Because then he doesn't have, an expectation of privacy, and therefore the Fourth Amendment, there's no violation of the Fourth. And in this, he's saying the same thing. The fact it was not disclosed necessarily allowed the magistrate to reasonably infer that no connection had yet been found. Yet she still found probable cause to authorize a search warrant, as was reasonably to do. Notice this word here, had yet been found. We'll see. Lack of victim's DNA in the apartment of the vehicle. Hair samples. The lab report, hair fibers were not consistent with the victim's hair. Exhibit, okay. Again, this evidence does not support defendant's assertion that law enforcement knew of the lack of victim DNA in his vehicle apartment on January 5th. They didn't know that. At best, it can be said law enforcement was aware on the 28th that the FBI test did not reveal the victim's hair fibers in defendant's apartment or vehicle. But it is evident from the various lab reports that law enforcement investigated with regard to DNA was still continuing, meaning they're still checking, is what the judge just said. They're still checking. Has not established by a preponderance of issue defendant identification. That's IGG. So let's get down to the bottom. The judge said, conclusion. Based on the foregoing, defendant's motion for a Franks hearing is denied. That means everything is moving forward. Everything, 100%. We'll see what's going to happen with the next motions now. Because she's not done. And she's not done. And you know what? She shouldn't be. I mean, that's her job, right? That's her job. Her job is to defend Bryan Kohberger. The state's job is to defend the victims. And so we move to the next level, whatever that level is, and hopefully the family gets some justice coming up. All right, ladies and gentlemen, friends, family, TIR family, thank you so much for sticking with me the last couple hours. This is a great day for the families and for the victims. And hopefully justice will be served. But God bless you. See you on the next one.
Hard working every day. I'm stressed out 24/7, babe. No timeouts. Wish we could fly away. You and I go to our favorite place. Oh yeah. Make special memories together. I'll be your company now and forever. I say we fly away. You and me go to our favorite place. Feeling the sun on my face in Hawaii. With you, Hawaii. With you, Hawaii. With you, Hawaii. I need a summer breeze, some fresh air to put my mind at ease. No cares. You wanna come with me? Me and you go to our favorite tree. Are you ready now? We jump on a plane now. We're taking away. Yeah, we're taking away. Don't hesitate now. We're taking away. Yeah, we're taking away, we'll never come down. We're going away, yeah, we're going away, you and me. Feeling the sun on my face in a way.